Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam Prosecutor.
Is this the only thing holding it?
I'm sorry, Your Honor.
Is the only thing holding him?
Yes, it is, Your Honor.
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Cause conference July 11th,
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Now here's where the defense starts tugging on heartstrings. No criminal history, longtime local, and parents borrowing from retirement just to get him counsel. It sounds compelling, right? But hold up. Stability on paper doesn't erase violent action. Let's see if this version of Joshua Smith holds up once the video evidence rolls in.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Mr. Smith and help in any way they can.
Okay, here's where the defense gets strategic. They're saying even if he's convicted of assault with intent to cause great bodily harm, the sentence would likely be probation. That's wild, because it sets up a clash. Nice guy with low sentencing guidelines versus dude strangled a 14-year-old. Let that sink in.
He has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter, Judge, and I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction.
Now they're asking for a $2,500 bond like this is some minor dispute. But things are about to take a sharp turn, and you'll see why that number is laughable once the prosecution speaks.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Boom. Everything changes. The prosecution flips the tone. This wasn't just a fight. This was an adult teacher strangling a 14-year-old student. On video, with a damn sweatshirt sleeve. That's no heated moment. That's rage. And if you're still feeling sympathy for Smith, wait for his own confession.
Your Honor, we originally requested a $75,000 cash as surety in this case, and we were given $75,000 with 10% privilege. This is a case that was completely captured on video. The defendant is a teacher at Ypsilanti High School. The victim in this case is a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old's face and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on is on video.
He had a headache and he snapped. Bro, that ain't an excuse, that's a confession. He knew what he did. No twisted alibi, no confusion. This is the moment that seals it.
Based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
Defense is still holding on like it's a traffic case. Saying 14 days passed with no other issues doesn't erase what happened. A teenager was assaulted by the very person who was supposed to protect him. Period.
Even with the
There was
series,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah,
And
go ahead with your response.
even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.
I understand, Judge.
Judge ain't playing. Motion denied, fast and final. There's no gray area here. The video spoke louder than the resume.
I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
And this last moment, chills. Defense tries to float a compromise. What if he lives with his mom? And the judge hits him with, when I'm done, I'm done. That's the sound of a door slamming shut. Justice, final.
I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the
There was
series,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah,
And
go ahead with your response.
even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.